So I'd like to verify that people can hear me and see my screen.
Yes, I can hear you. I think I see your screen.
You should see American LegalNet Docketing Best Practices with the Ides of March coin on it, which I thought was appropriate for today.
Yes.
Today is March 15th, and in 44 BC, one Mr. Julius Caesar was assassinated on this day. So therefore, beware the Ides of March.
Watch your back, Dan.
Thanks, Tom. I think Donald Trump might have more to worry about than myself, but
You want to take that chance.
We will not talk about politics in today's conversation.
Thank you.
All right. So thanks everyone for joining. We're going to talk today about docketing best practices. An exciting topic in my mind, and really the purpose of this presentation is go through the various practices we've seen out there, some of the benefits of each of the different ways in which you might manage a docketing solution inside a firm. And at the end of the presentation, I'd like to answer any questions as well as hear from members of the audience what your best practices are and some things that you'd like to talk about that you're experiencing at your firms. So we're start out with a little background here. First of all, I'm the presenter. And I want to give everyone a little bit of background, and I have been, I started working at a law firm at age 16. I worked at my uncle's firm as a runner, and I did a lot of different things. After that, I worked in both large and small firms. The largest firm I worked at was Paul Weiss in New York. I eventually practiced law in California. I did complex civil litigation. During the course of practice, I discovered that I'm not really the most adversarial person on the planet, and litigation wasn't really meant for me. And I'd always been a bit of a computer geek, if you will, and I had was always into programming, coding, and so I decided to go back into my passion of programming and join that with my law degree. I started working for Elite, where I wrote the conflicts and case management systems. Elite was acquired by Thomson Reuters, and while at Thomson Reuters, I was involved in many studies out in the field. And part of the reason I'm giving this background is so you get an idea of where some of what I'm going to present today comes from in terms of best practices. So while at Thomson Reuters, I was engaged in studies where we literally would watch attorneys, what they did during the day. We did focus groups. We did analysis on profitability of law firms, on various operational aspects of law firms. I would be interested to find out if there's an area of the law firm that's a significant area of practice that I haven't studied. So we definitely turn things inside out and try to look at everything from end to end, created what were called heat maps in terms of law firms' capability and where they needed development and where they did well. I've worked on, in addition to obviously case management, calendaring, and conflict system, I've also worked on financial systems, legal practice management systems, and marketing products. So I've got a good sense of kind of the end-to-end needs of a law firm when it comes to software solutions. And I've been here at American LegalNet for 18 months, and over the course of 18 months, I've gotten to know many of you who are joining today's seminar, but I've also got the opportunity to talk to firms about how you're using the systems today, both firms that are clients, but also prospects who have different practices in place today. And I've gotten to see kind of an end-to-end use of the solutions across the country when it comes to docketing and calendaring. So, compared to when I practiced law, we live in what I would call a new world order. Back before 2008, 2009, it was all about the effectiveness of counsel. So it was all about how effective one was in terms of presentation. So I would literally spend sometimes 20 or 30 hours on a motion that I knew had a very small chance of success just because I wanted to leave no stone unturned. You objected to everything you could object to. You did everything you could in order to win your case, all about effectiveness of counsels, and the hours didn't matter because the clients would pay the bill. There was a saying by the General Counsel of General Electric that every year I'm given an unlimited budget, and every year I manage to exceed it. Now, how can one exceed an unlimited budget? It's the unpredictability of the litigation costs. So the partner, you go to the partner, the general counsel would come to a partner at a firm and say, how much do you expect this to cost? The partner might say, I expect it to be $500,000. Next thing you know, the bill's $2 million. And there was a time when corporate clients would pay that. In 2008, 2009, we had the Great Recession. This is the first recession since World War II that impacted law firms and the finances of law firms. Until that point, law firms were often described as recession-proof. That proved wrong in 08 and 09 when, for the first time ever, when the partner said, I think it's going to be $500,000, corporate counsel said, I'm sorry, we only budgeted $500,000. We literally cannot pay and will not pay you more. So that $2 million bill is very interesting, but you're only going to get $500,000 from us. And that was a shock to the legal marketplace. For the first time, firms were expected to stick to a budget or to follow a fee cap. And since that time, we've had a huge increase in the number of what are called alternative fee arrangements, alternative to the hourly billing practice. And what these corporate clients were asking law firms to do was to become more efficient. See, law firms, while always being about effectiveness, hardly ever had to worry about the concept of efficiency in those days. Efficiency is very much a corporate concept around manufacturing and production. The idea is to do things as efficiently as possible to drive down the cost of goods, to make it so that things are really inexpensive. And we've seen that in our day-to-day lives. We've seen the price of electronics drop. We've seen all sorts of new goods drop, furniture pricing drop. We see what it can do when the focus is on efficiency. So now law firms have this conflict between how do I be as efficient as possible, how do I deliver effective counsel, how do I deliver accurate advice to my client, how do I make sure I don't miss a deadline, but do so at the lowest possible cost. And in the case of law firms, cost is almost always directly correlated to time, because the most expensive cost inside a law firm is salaries, by far. So how does one generally increase efficiency, right? So we've seen this in manufacturing and other areas. First of all, we specialize. We take less time to perform the same task when we're specialized. It takes someone, if you know how to calendar for your jurisdiction and you do it day in and day out and you calendar motions every day, you're going to be super efficient at that. If this is the first time you've had to calculate a date, like let's say that you're an attorney, does this yourself, and it's the first time you've had to calculate a date in this jurisdiction on this particular type of event, say it's a motion, it's going to take you a while. It might even take you several hours to figure out how to properly calculate those dates. And you may not do it right. The other thing that you see on the slide is training. It turns out that lawyers think that they know everything, and they do, many lawyers do know a lot. But when it comes to calculating dates, I can tell you from experience that they're often wrong. In fact, there probably isn't anyone on this call who has not had a lawyer miscalculate a date or get a date wrong and had to be corrected by a staff member. Because the fact is, they don't do it every day. There are a lot of subtleties to the rules. There's a lot of other conditional rules that they may not be aware of. And so it is often the case that their first attempt to calculate a date in a jurisdiction they're unfamiliar with is incorrect. And obviously, the big thing that's used in manufacturing and other areas are tools. Tools will help us be more efficient. There are many things that we do that are mundane or routine which can be automated and done by tools. They can help us with workflows, and they can eliminate tasks altogether so they don't have to be done by a human. For example, calculating, well, here's today's date, what is 13 court days from today in this jurisdiction? That is something that can be easily automated. In fact, when it comes to industrial efficiency, many people put the start of kind of, if you will, what's called the scientific method of management started with this man, Frederick Winslow Taylor. What he did back during the Industrial Revolution is he came up with a way to approach things in a scientific method. In other words, instead of saying, that feels better, I think we're doing it more efficiently, or that seems to work better for me, he actually used scientific method to replace rule of thumb work methods with that based on scientific studies of tasks. One of his most famous studies was analysis of the proper size shovel to use to put coal into the furnace, because you needed to put coal into the furnace for an 8 or 10-hour shift. If the shovel was bigger, obviously you get more coal per scoop. But if it was too big, the worker would get worn out quickly and shovel far more slowly. If the shovel was too small, it'd be easy to shovel all day, but you wouldn't get as much coal in. So did a lengthy study in which he determined the optimal size shovel for coal. That's kind of the nature of the study and how it works. Also, you need to train and develop employers rather than passively leaving them to train themselves. In other words, there's a common thing that happens inside of law firms, perhaps not all firms, and I know many firms have improved, but certainly when I started working in law firms, it was often you were thrown in the deep end of the pool. I remember I was 16, I was a runner for my uncle's firm. I was often sent to court with not really instructions on what to do, just said go ahead and file this or figure out what to do here, and you would go and you would figure it out. That is not the most efficient way to work, and it's not the best way to make sure that everyone is doing things consistently with the highest level of quality. It's important that every worker, every person who's producing work product has detailed instruction and supervision on how to perform their work. So this is what you want: instruction manuals, you want clarity. You bring in somebody new, especially into a docketing accounting environment, who hasn't done it before, they need a lot of specialized knowledge and detailed instruction. The last point here is about kind of this management and direction versus actually doing. There is a tendency on the part of lawyers to try to do things themselves, like calculate the deadlines and the dates, and that's not the most efficient use of their time. They should be oftentimes working on the strategy and direction of a case, and leave things like the deadlines to others for the sake of efficiency. So these are the concepts that your clients, your customers are using to run their business, and they're the same kind of concepts they want you to use inside the law firm in order to become more efficient. So how does that apply to docketing? What we're going to do here next is we're going to go through some models that we've seen out there in the world of the docketing function, and they go from fully distributed to fully centralized. I'm going to go through each one in some detail, and we're going to talk about the pros and cons of each of those models. First of all, decentralized. This by far is the most common model in the small to mid-sized firms. You see it in large firms, and it's just rarer there. Oftentimes people like to compare lawyers to sharks. I prefer to compare lawyers to dolphins, especially when they're inside a firm. They tend to work in pods. So while an individual may be counting for themselves, what tends to happen if you're working on a larger case or a case with multiple people on it, they're working as a pod together, and someone's been assigned to help with the calendaring. Sometimes it's an associate, sometimes it's a paralegal, but then in a different case, someone else is doing the calendaring, even though they're working in a similar pod. It's very ad hoc. It's very much for a particular purpose. Not everything gets calendared. Only things that are felt to be important or significant deadlines show up on the calendar. What is important is what is significant varies by working group. So you get a lot of inconsistency here. There are some pros to this. First of all, there's a low initial cost. You use it with existing staff. There's no additional staff added for this. Super tight communication loop because the people who are doing the calendaring are doing the work. So they know that they've got a discovery motion that came in, and so they know to calendar for it. And it's super flexible. If you know you're working in California where a trial can generate 130 deadlines and you say I actually only care about these 12 or 20, you can easily do that. The problem with it is it has a high ongoing cost. That is, relatively speaking, each calendar entry is super expensive to create because the amount of time that the individual involved in creating it is relatively high compared to an expert. There's also a highly increased chance of errors. By far, most of the errors in calendaring happen with these decentralized models. Time use when you could be working on other things is not great. You could be working on actually producing work product on the case as opposed to calendaring. And bringing somebody in or training people in a new system, for example, if you decide, like some clients have, purchase e-dockets or other solutions and use the distributed model, training is super expensive because you've got to go to each individual involved in each office to do the training. So the training costs on a system to do calendaring is very expensive when you have a decentralized model. And then the turnover is high. So if any one of those nodes turns over, anyone who does these calendaring in the distributed model, they've got to be retrained. So ongoing costs, again, very high. But low initial cost, almost no capital involved. So a lot of firms do this as a way to get into it, to get started. The next kind of model, which I would call the hybrid model, is the centralized by office or practice group. This is the most common model, I would say, in the AM Law 200 firms today. So you'll have an office that calendars perhaps litigation in this office. Litigation in Atlanta is calendared this way, and IP in DC is calendared this other way. And maybe sometimes we do it ad hoc, or there's a small group that does it differently than another group. But there is some logical grouping starting to happen. There's some idea that we could get some efficiency by having someone be responsible for this. So the pros are that this is obviously specialized in the sense it's around a practice group or jurisdiction. So the people tend to be very familiar with the rules involved. Therefore, it's less error prone. And it has a lower ongoing cost than the fully decentralized model that we talked about earlier. There, of course, is some initial cost. You often have to hire a staff member or designate an existing staff member to be responsible for this function. The coverage for the staff can be problematic because it's often one or two people who are responsible. So if they're out sick or they're not working, there's an issue. You're not able to cover the full 24/7 that many firms want. There's a medium training cost to this. It's obviously less expensive than a fully distributed model, but you still have to go out and do training in multiple offices, and the turnover may be an issue. And staff utilization, some staff may be underutilized while other staff is overutilized. What I've seen here is New York's super busy while California is not so busy one day, then California's super busy when New York's not so busy. So you start to see these kind of disproportionate work on a daily basis. Maybe over time it works itself out, but on any given day, someone is overworked and someone's underworked. So the final model that we've seen at a few firms is the fully centralized model. This by far is the most efficient. This is literally where there is a docketing department responsible for 100% of docketing. All the people report into the same individual. They have a department organization. They may be in multiple offices, usually are. There may be some in California, New York, Chicago. And this model is by far the most efficient. It is least error prone, in part because not only are you specialized in doing this, but also there tends to be, these models tend to involve some sort of review process or what is known as 4 eyes, which is at least 2 people have looked at everything that gets docketed. They have the lowest ongoing cost because, again, they're centralized. They can do more calendaring with fewer people. Lowest training costs because there's usually only one training location that has to happen. Even if people are in multiple offices, when it comes time to training, they're usually all flown to the central office, and then everyone is trained there. you're able to cover across offices. So, hey, New York can cover California in the mornings, and California can cover New York in the evenings. And this definitely leads to a lower overall cost. The cons with this, and the reason every firm hasn't gone this direction, is there is a higher initial cost. You have to hire professional staff, and you need a management layer on top of this. So there's an initial cost here that's fairly significant. It requires enforcement. It requires change in the way the firm practices often. It requires a general counsel or managing partner or combination thereof to enforce this across the organization and say, this is how we do calendaring. There's no other way. Everything that happens in this firm has to go through the calendaring department. And that means it needs more communication from the lawyers. The lawyers have to consistently communicate with the calendaring department. So while it might be easy to get some of the obvious stuff, such as the filings and the motions, other things like discovery, which can happen without filing, what the court often does, and other more informal deadlines have to be communicated to the team so that they're not missed. So that's kind of the one end of the spectrum. So we've gone from one end to the other end of the spectrum here. And the fully centralized model is the newest model, and we're seeing it more and more. So I can say that I'm definitely seeing a trend out there going from decentralized to partially centralized to fully centralized. The other thing that varies from firm to firm is, what else do I have to do? Yes, I'm responsible for calendaring, but I may also be responsible for court filings. I might have to do some records management activities. I may have to deal with legal holds. I may have to track bar admittances. I may have to do conflict checking and other clerical activities, if you will, that are associated. This varies greatly by region. For example, it is common in New York to have a managing attorney or managing clerk's office, which is also responsible for filings and perhaps even bar admittance and some other areas, but they're usually responsible end-to-end for kind of how we're approaching this, where we're going to court, what we're filing, a lot of details on how things are filed. When we compare that to California, in California it's often the case that the docket calendaring function is purely a dedicated docket calendaring function, and the person responsible for filing might be is often a different individual, or often a PA is responsible for filing. So I've seen that variation, and a lot of it has to do with kind of the history of those markets, as well as the way law is practiced a little differently in those markets. As I mentioned, a trial in California can generate 130 deadlines, so there's a lot of calendaring activity in California. There's fewer deadlines, often 15 or 20 associated with a trial in New York. So some of that is part of the variation. Also, the fact that New York has a concept of a managing attorney, which is an actual lawyer who's practiced, who understands the filing of the clerks. A lot of them came from the clerk's office and know what needs to happen there in order to get filings accepted, and a lot of the details around filings are not as standardized as they may be in California. So these other responsibilities, though, are really important because they lead to some of those inefficiencies we talked about earlier, and ideally we separate the functions down into as discrete parts as possible, just like when Ford came up with his approach to making cars. He's like, okay, everyone, instead of building a car end-to-end by hand, someone's going to put on the wheels, someone else is going to put on the doors, and it was super efficient. So we have a lot of information to manage. So if you're responsible for docketing and calendaring, there's a lot of information you need. So some of the best practices we've seen out there is filtering all mail. So all mail comes through the mailroom. If it is involved in litigation, if it looks like it's anything to do that's going to generate a date, we scan that document and we docket it immediately. This is the best practice. It is common in the larger firms, more common than it is in smaller firms. That's what I'll say there. On the electronic side, we've got some issues. I was talking to a CIO who said, you know what I'd like to do? I'd like to filter emails to see if there's any kind of discovery document in those emails, because oftentimes we agree to electronic notification and we get our notifications for discovery in email, and I'd like to be able to filter on our emails to find that. The technology I don't think's here yet, but I know there's some people working on it. We'll see how that comes along. The other thing is you want to be included on e-filing lists. As you know, with Pacer and with other electronic filing services, there's the ability to add parties, and it's important that the docketing function or centralized mailbox for docketing be added on all those filings. And of course, the attorneys need to always forward information to you. Now, yep, the downside of this is if you're both on the Pacer notification and all the attorneys are emailing you the Pacer notification, your email box is overflowing with the same information. But there is a benefit to that redundancy in terms of not missing anything. The other thing is all verbal communication. Anything that has been said between you and an attorney, between the docketing clerk and the attorney, should be followed up in writing. The same practice we have here for our court rules attorneys. So we have a team of court rules attorneys who communicate with clients, and sometimes that communication is verbally over the phone. They've all been instructed to send a follow-up email clarifying what was talked about and what was said about that, so that nothing is lost in the process and no one misunderstands what was communicated, because our memories, as we all know, are fallible, at least mine is. So I'm going to talk a little bit about working with lawyers. It is not your imagination that lawyers are difficult to work with. It turns out that difficult people make good lawyers. And there was a great study done by Virginia Tech Law School about, they did a longitudinal study where they did a personality analysis of their incoming classes, because the LSAT is a terrible predictor of success in law. And they tried to determine what personality traits lead to success 10 years later in the practice of law. Turns out the #1 trait for being a successful lawyer is being a pessimist and being a negative person. Good lawyers see risk where no one else sees risk. The good lawyers are people who will challenge anything immediately. You say, oh yeah, we'd like to, we're going to be repainting the offices. It'd be like, why? Why are we repainting them? What color are we repainting them? What, do they need to be repainted? What's your premise? It is always interesting and challenging to work with lawyers, and that means that getting them to cooperate means that you've got to buy their trust. You've got to build trust and develop that type of relationship with them. They need to know that they need to include you in all correspondence. They will understand the risk management. The one thing they do understand about docketing and the risk management component is that there is a risk. Their license is on the line, so they may want to double check work and stuff, but ultimately they'll want the backup because they'll want to make sure that they don't run any risk of being disbarred. Obviously, you've got to collaborate. Cooperation, collaboration, right? We've got to work together. We've got to get information back and forth between us. And shared responsibility, because as I mentioned, the lawyer is ultimately responsible under the ethics code for missing a deadline. There's a concept that I really like that I only know of as in practice at one firm, but I'd like to see other firms engage in this practice as well. It's the designation of a DRA. A DRA is a docketing responsible attorney. It is someone who is working on a case who is specifically responsible to make sure anything relevant to docketing gets to the docketing calendaring team. I think it's a great practice and would like to see more of it out there. When it's someone's job responsibility to do it, it usually gets done. When it's no one's particular responsibility for it to get done, it might get done, but sometimes doesn't. So quality control. Obviously, we don't want to miss a date, so all docket dates need to be reviewed for accuracy. Got to make sure we're applying the correct rule. Okay, we got this document. It's an appeal. Did we notice the right type of appeal? Is the method of service relevant? Holiday dates. Do we want to move the date forward? The good news is a lot of this can be automated, and we obviously have tools to automate that. Some methods of review is a number of our clients use something in our software called the Just Docketed report to see what was docketed that day and review it, make sure it's correct. We also have a concept of setting something in a pending state. You can bring a new docketing clerk on, put something in pending. It won't show up on the attorney's calendar. No one will get notified of it until it's made active. So that gives you a second pair of eyes that can go through and look at that pending data to make it active. And of course, attorneys should always be validating the data in the sense of they should make sure, yep, that makes sense, it aligns with the date that I was expecting it to do. They tend to do this. They tend to tell you when they think it's wrong. More often than not, they may be wrong that you miscalculated a date. That seems to be the experience that everyone out there has had. But it shows that they're paying attention and that they care. So you'll remember one of those things that Frederick Winslow Taylor talked about was the importance of education and training. I cannot emphasize enough that this is going to pay for itself several times over. And you've got to do it at all different stages. First of all, at the onboarding process. Anytime a new employee starts, you have to give them training. Obviously, if they're a docket calendaring employee, you're going to give them in-depth training on docket calendaring. But if they're an attorney or summer associate, when they come on board, they should understand the docketing and calendaring processes inside the firm. Time they first take on a new case. All right, I see you've just been assigned to a case. It's the first time you're doing a case here. I want to talk to you through how we do it. Make sure that I know you got it in onboarding. I just want to make sure you understand it now. Again, online courses, brief 15-minute online videos. Self-education is a great way to make training available. And make sure at least once a year that a refresher is out there, that they've got refresher training available. Certain organizations will require it as part of their ethics compliance, that it's included as part of their overall compliance package each year. While you're training them in other things they need to be worried about, like their ongoing continuing education, it's a good thing to remind them of how they need to be calendaring. So, obviously what I've talked about here is docketing best practices. And I'm just going to tie it up here with how our eDocket solution, American LegalNet, helps improve those efficiencies that I talked about. It does so by allowing you to use a single system across the country. You don't need a different system in New York and a different one in Chicago and then use a different one in California, as some firms do. We have the ability to bring in docketing data automatically from the federal courts. We've got what's called the auto docket feed. So when you've got your PACER receipts coming in, you can bring those into the system automatically and calendar them. We also have the docket direct feeds from courts in New York, Illinois, Delaware Chancellery, and others that allow you to actually get the docket data from the court's calendar and bring it in. This is also another quality control method. So most of the time people use this docket direct feature to verify the dates they already have calendared are correct. We obviously have a team of attorneys that writes court rules and makes sure that those rules are kept up to date. We support the quality control workflows through the methods I mentioned, such as pending and active. So you've got the ability and flexibility to go in there and really make sure that before something gets on an attorney's calendar, it's been reviewed. And we have an easy-to-learn web interface with our software. And so that's it for my presentation today. With that, I would like to open it up to the audience for questions or comments. Anyone have any questions or comments?
This is Olivia. I wanted to make a comment, Dan. Olivia Baines from Venable. I just wanted to commend you. I thought it was a great presentation, and I really liked how you break down how efficient docketing departments. I think most of you could agree that often we get a lot of these questions from the attorneys, or even as managers, we have to present to a group of attorneys or even new attorneys joining to the firm. So it's really nice to see that breakdown, and it's just a good reminder. I know I am actually in the middle of writing a presentation for one I have to do in a couple of months for a practice group leader, so it just gave me an idea of some other ideas I'd like to bring in. So I just wanted to say thank you.
Appreciate that, Olivia. Thank you very much. Well, on that positive note, I'd like to mention that I will be around the country doing a similar but more technology-focused presentation. We have the ILTA Roadshow in partnership with ILTA, the legal technology organization. Hopefully some of the more technical people at your organizations will be joining me on that roadshow. Details of those dates can be found on our site and will be distributed through emails and other things. And if anyone would like a copy of today's recording or a copy of this presentation, please send me an email. Thank you, everyone, and have a great day. Happy Ides of March.
Thank you. Thank you.
Thanks a lot.